It is 5:31, and I want to be respectful of everybody's time this evening. So I don't want to take up too much of the time. Our president is out this evening. He is sick. So I'll go ahead and get us started, and I'm going to immediately go ahead and mic pass over to you.
Wonderful. So thank you for inviting me and having me here today. My name is Alexandra Iwanenko. I'm an immigration law attorney here in Erie, but I also am a City of Erie resident. And I love that I live in the City of Erie, and I'm really glad to be able to talk to City of Erie residents about an issue that really is important. So the first thing I'm going to do is start with definitions, just to make sure we all know who we are talking about, because a lot of times these terms are used interchangeably, and people think we're talking about the same groups, and we're not actually talking about the same groups. So the first group we're going to talk about is a refugee. Who is a refugee? A refugee is a person who fled their country because of serious human rights violation, persecution, and the U.S. government is actually the sponsor in the case of refugees. They bring refugees here. It's a legal process. Refugees get their refugee designation through the United Nations outside of the U.S., and when they enter the U.S., they are entering with refugee legal status. They are very likely assisted by refugee resettlement agencies. There are 3 locally in Erie who provide assistance for the first 90 days. Housing, employment, language access, getting kids enrolled in school, getting their social security cards, getting their work authorization. They do get work authorization, they do get social security numbers, they are able to work, many of them do work. They open their own businesses, they pay taxes, and this group is very important to Erie. It's very important locally. And the important thing to remember about refugees is they didn't choose to be refugees. When I talk to refugees, a lot of them tell me they want to go home if they could. They don't choose to be displaced from their country. They also don't necessarily choose to come to the U.S. So refugees don't get to pick what country resettles them. Parts of families might go to Canada, Australia, Germany, Italy. You don't pick what country you go to. So this is not a group that are choosing to come here and choosing to live off of a system and choosing to get government benefits. They're sponsored by the U.S. government. They are brought here because they can't live in their home country, and they are provided assistance for the first 90 days. Some numbers locally. This is from 2023 to 2024. Important to note, this does not include the influx of people that were resettled from October to January prior to the change in administration. Refugee resettlement agencies locally were asked to bring in as many people as possible, full capacity, as many as your staff can handle, with the anticipation that refugee resettlement was going to stop under the new administration. And that is, in fact, exactly what happened. So the total number that we saw in Erie was 1,291 in that fiscal year 2023 to 2024. These people, the top 5 countries were Afghanistan, Democratic Republic of Congo, Syria, Ukraine, Venezuela, Colombia, and Guatemala. Again, these are people who all have legal status here in the United States. The top languages are Pashto, Dari, French, Lingala, Swahili, Arabic, Ukraine, Russian, and Spanish. And so we do have a lot of diversity here. We do have a lot of languages that are spoken, and it's even more important why we need to provide supports to the refugees locally. What we've seen since the change of administration is the suspension of U.S. refugee admissions program. This is a complete halt to refugee resettlement in the United States. It is non-existent. There are no refugees who are entering the United States right now. We've also seen a suspension of the Welcome Corps program. That's a private sponsorship group where groups of 5 people in the United States, U.S. citizens or green card holders, could come together and financially support refugees. They would take the place of resettlement agencies. So the supports that the resettlement agencies provided for the first 90 days, these groups of 5 people would take that place. They would be responsible for providing those supports. That program has been completely suspended. I handled over a dozen cases of Welcome Corps programs where families were being resettled into Erie through this sponsorship program, and some of them had flights scheduled. They were set to arrive the first week of February. Their flights were canceled. They were no longer allowed to come because the program was suspended. And they had made it through the entire process, through all the vetting, through their medicals, their interview. They had flight tickets. Everything was set for them to arrive, and that has been completely shut off. And the last thing that has changed with... Sure.
It's a private program. Mm-hmm. Shut it off.
So it is still run through the federal government. The referrals would come through the United Nations. The United Nations would then place those refugees with the groups here that were ready to sponsor them. So although the financial component was private and the groups of people were willing to provide those supports, you still needed the federal government to coordinate their travel for entry, and that has what's been stopped. And so the last big change that we saw is a federal funding freeze for refugees. That means the resettlement agencies here who already promised to support the refugees for the first 90 days has had their funding completely stopped by the federal government. So it's one thing to not allow new refugees to come in. It's another thing to not support the refugees who are already here. And so those supports for the first 90 days have completely been cut off as well, even for people who have already been resettled by an agency. That means layoffs for the agencies. If there's no more refugees, there's no more need for caseworkers. And that means there's not as much support for housing, for job training, for those English classes, because there's no more funding to provide those services. The next group are asylum seekers. The big difference between asylum seekers and refugees is, as an asylum seeker, you have to be in the United States to seek asylum, or you have to go to a port of entry. So you can't apply for asylum from outside of the US, different from refugees who get that designation and they enter as a refugee. An asylum seeker has to go to a port of entry, or they have to already be here. And the legal definition is the same. So there's fear of persecution in their home country. They feel like they can't go back based on a protected ground: religion, nationality, political opinion, social group. And there's 2 processes that they go through to apply for asylum. One is called affirmative. That means you're in the US legally. Maybe you came on a visitor's visa and something happened in your home country, you can't go back. Maybe you're here on a student visa and something happened in your home country, you can't go back. You're legally here. You can apply for asylum with USCIS, U.S. Citizenship and Immigration Services. It's an agency you submit your application to. The other way you can apply for asylum is called defensive asylum. That means you go to a port of entry and you say, I can't go home because of this fear, and you ask the U.S. government to allow you in until your case can be heard with an immigration judge. You have no legal status in the US. Maybe you entered unlawfully and then you decide you're applying for asylum, or you're already in immigration court. There's already been paperwork filed saying you're here unlawfully and deportation proceedings have started. You're using asylum as a defense. You're saying, okay, maybe I entered unlawfully. Maybe I'm here without status. But my defense is that I can't go back to my country, and so I'm asking for asylum because I'm fearful of going back. And those 2 processes are completely different and are often conflated, because USCIS is called a non-adversarial process. When you go, it's you and an asylum officer in an office It's a conversation. There's no judge, there's no attorney on the other side trying to deport you. There's just an investigation into your case to see if you have a valid claim of asylum. In immigration court, there's an immigration judge, there's an attorney for the government who is prosecuting the case to try to deport you, and you may or may not have an attorney. There is no requirement to have an attorney in immigration court. If you can't afford one, one is not appointed for you the same way it is in the criminal justice system. So only about a third of people in immigration court are actually represented, and that's why the approval ratings are so low for asylum cases, because it's really hard to win your case when you don't know what the law is. Changes related to asylum, the CBP One app that was created under the prior administration, you could download that app on your phone, you could make an appointment to go to the US-Mexico border and talk to an asylum officer and say that you are there to seek asylum. That has been terminated. There is no longer a way to apply for asylum at the border. There's also now unspoken quotas for immigration judges. So they might be told, you have 100 cases this month that you can approve. And then they need to be really careful about what cases they're going to approve and what cases they're not going to approve so they don't run out of their approvals. And right now the approval rating for asylum cases is 25%. So you have a 1 in 4 chance of winning your case. You could have the best case, you could have the best attorney. If you have a very zealous government attorney, or you have an immigration judge that has a 9% approval rating, and some immigration judges have a 9% approval rating, there's a lot that's going to be against you in court. The next group is a parolee. Parole is a temporary status, and this typically allows you to stay in the US for a 1-year period or a 2-year period for humanitarian reasons. Parolees do not have a pathway to a green card. It's temporary. You come here, and the idea is whatever's happening in your home country is going to get better, and in 1 year or 2 years, you will be able to go back. What we've seen parole used for is the Afghans who entered the US during the fall of the government in 2021. Over 70,000 Afghans were paroled into the US for initially a 2-year period, with the idea being, I think, after 2 years they would be able to go back to Afghanistan. Given the political situation, that's not what happened, and their parole was extended for another 2 years, set to end this year in 2025. And so if they haven't applied for asylum, or they haven't applied for a special immigrant visa, they are going to have to leave when their parole expires, unless they have another option to stay. And so that's something that has been very difficult for that group, because the US government brought the people from Afghanistan here. A lot of them were interpreters with the US government. A lot of them worked with the US military in Afghanistan, and they're in a little bit of a limbo right now when this is going to be set to expire in August and September of this year. The other large group who entered under parole were Ukrainians. United for Ukraine, the U4U program, that is a parole-based program. Very similarly, parole was set for a 2-year period, set to expire this year. And so a lot of Ukrainians now are trying to figure out, if they don't have a pathway to a green card, how are they going to be able to stay? If they haven't applied for asylum, if they don't have another way to stay legally, what does that mean? There's still a war going on. Are they supposed to go back to Ukraine? We don't anticipate parole status to be extended. In fact, the opposite is what's happening. So this administration has revoked parole status for over 900,000 people who entered on the CBP One app. Remember, CBP One is the app you download, you go to the border, you ask to be allowed to come in. That was a legal process set up under the Biden administration. This administration believes that the app was unlawful. Therefore, they are revoking parole status for almost 1 million people. They've also terminated the parole status for Cuban, Haitians, Nicaraguans, and Venezuelans. That's about 500,000 people who were granted that status. Again, a legal status. They submitted an application. They were allowed into the U.S. with that status, and that status is now being terminated. From what we've seen, Ukrainians and Afghans who have parole, their parole isn't being revoked, but their parole is also set to expire this year. So a lot of the people who entered with CBP-1 or in the Cuban, Haitian, Nicaraguan, and Venezuelan group, their parole was set to expire next year. So this is a way to terminate their parole before it was set to expire. We also have temporary protected status. This is given to people from countries that are experiencing armed conflict, natural disasters, or other extraordinary conditions. Someone might qualify for TPS because their country is a war-torn country. War in itself is not a basis for asylum. So just because there's instability doesn't mean you qualify for asylum, doesn't mean you qualify for refugee status, but you might qualify for TPS status, or you might have been paroled into the U.S. TPS gives you the legal ability to work. You do get a work permit, you do get a social security number, you also are able to do those things under parole, and if your asylum case is granted, just for people, because I didn't mention that for the other two statuses. Right now, countries with TPS has to be designated by the Department of Homeland Security, it has to be designated by the U.S. government. So if your country is not designated, you can't apply for TPS. That is up to the current administration. The current designations were Afghanistan, Myanmar, Cameroon, El Salvador, Ethiopia, Guinea, Haiti, Honduras, Nepal, Nicaragua, Somalia, South Sudan, Syria, Ukraine, Venezuela, and Yemen. What we've seen under this administration is termination of TPS for Venezuelans. Their TPS status was supposed to last until October of 2026. This is affecting up to 472,000 Venezuelans who have TPS status. This decision is being challenged in federal court right now. It's being litigated, so there is a temporary pause on removing TPS status for Venezuelans, but we are not sure how the court is going to decide on that. And DHS also vacated the 18-month extension for TPS for Haiti. So that was something the prior administration had extended, and this administration has terminated. Non-immigrant status is someone who enters the U.S. on a temporary basis. This could be for tourism, like a B-2 visitor's visa. This could be an F-1 student visa. This could be short-term employment. But the idea is that you intend to depart once your purpose is completed. So for example, a student, once your studies are completed, you would leave. If you're just here to go on vacation, once your vacation is complete, you would leave. You have to prove you still have a residence abroad, your intent is not to stay here permanently, and it's really supposed to be temporary. What we are seeing with non-immigrants is affecting international students. Numerous universities across the country are reporting that their international students' CVIS record is being terminated. Their CVIS record is what gives them the ability to go to class or work if they have OPT, which is the ability to work after they've received their degree for a one-year period. In the past, these CVIS records have been terminated for criminal activity. Someone is convicted or they plead guilty to a certain crime. What we are seeing right now is something as minor as a traffic violation being the cause for terminating a student's visa. Something like political activity, attending a protest, could be a reason to terminate their CVIS record. And most concerning, at least from the legal perspective, that's different in immigration from the criminal system, is in the criminal justice system, you're innocent until proven guilty, right? So you could be charged, the charges could be withdrawn. You could be charged, you could be found innocent. Right now in immigration, if you are charged, you are losing your benefit. It doesn't matter if the charges are withdrawn. It doesn't matter if you're found guilty. The nature of having a criminal charge is, in this administration's perspective, a violation of your non-immigrant status, and your visa is being taken away from you. We are not sure exactly how this is going to play out. Upon termination of your student visa, ICE does have the ability to initiate deportation proceedings. We haven't seen ICE initiate deportation proceedings, so students are kind of left in a limbo, right? They can't go to class, they don't have a CVIS record, they're not being deported, so what are they supposed to be doing? There are international students here in Erie who this is affecting, yes, amongst the universities locally. And this is also affecting the economy because, as I mentioned earlier, a lot of them do have jobs. They've graduated and they've received that one-year OPT, and they're working for our local employers, and now they're being told, your underlying visa was terminated, so the work authorization based on that visa is no longer good. You can't go to work tomorrow. And that's really affecting the employers as well. And because this is unprecedented, we are trying to figure out exactly how to respond and what this looks like. A permanent resident is also a green card holder. You have a right to reside indefinitely in the U.S., to work indefinitely in the U.S. It's typically issued for a 10-year period, but it can be taken away if you do something that makes you deportable. And I think, I'll get to it in one more slide, but that's the biggest misconception. A lot of times we get calls from green card holders who say, I've been placed in deportation proceedings, but I have a green card. How is that possible? And we have to explain that even though you have a green card, you're not protected by everything. And if you commit certain crimes or you plead guilty to certain crimes, your green card can be taken away. Different ways that people obtain their green card. One could be a family-based petition. So you could have a U.S. citizen spouse, a U.S. citizen parent, a U.S. citizen child, or a U.S. citizen sibling petition for you. The wait time depends on who that relationship is. So if you're a spouse of a U.S. citizen, or you're a child, you're unmarried, and you're under 21, there's no visa wait time. Visas are immediately available. You can submit your application, and you won't have to follow what's called the visa bulletin. The visa bulletin is how many years you have to wait in order to get your visa. If you're a sibling, or you are a child and you're over 21, or you're a child who's married, you do have to follow the visa bulletin. I should have put it in here. I'll happy to share it, but the visa bulletin, for example, a U.S. citizen who wants to petition for their sibling from Mexico, the applications right now that are being processed are people who applied in 2004. So when your choice is to wait 20 years for a visa to become available, or to maybe enter unlawfully or come lawfully but overstay, maybe you come on a visitor's visa but you never go back, that's why a lot of people are in this situation, because the system is not really set up to adjudicate these cases very quickly. The other basis to get a green card is employment. You could be sponsored by a U.S. employer. Maybe you have certain skills, you have a certain education, a certain ability that employers are looking for. They can sponsor you for a green card. There's all different letters, we call it alphabet soup. There's EB1 through 5, there's L's, there's O's, there's P's, and the different visa that you apply for depends on your job, your experience, your resume, and what the employer is looking for. And then you can also get your green card based on the humanitarian processes that we talked about earlier. Refugees and asylum seekers can apply for a green card after they've been in the U.S. for 1 year. There's also other ways people are eligible for a green card. If you are a victim of trafficking and you cooperate with the investigation, you could be eligible for a green card. If you are a victim of a crime and you cooperate in the investigation, you could be eligible for a green card. If you are a special immigrant juvenile, so you're under 18 and you're unaccompanied, there's no parent here, you could potentially be eligible for a green card based on that status. Or VAWA, the Violence Against Women Act. If your abuser was your spouse or your parent or your child and they're a U.S. citizen or a green card holder and you were abused by that person, you could also be eligible for a green card through VAWA. Those are ways to get a green card. These are ways to lose your green card. If you stay outside the U.S. longer than 6 months, your green card can be taken away. As a lawful permanent resident, you have to be permanently residing in the United States. So the U.S. government says if you are outside the country longer than 6 months, you're not permanently residing here, and they can take away your green card. If you have criminal activity, like I mentioned, certain drug offenses, felonies, things that are called crimes involving moral turpitude, that could affect your green card status. You would be placed in deportation proceedings to take your green card away, and once your green card is taken away, if you have no other legal status, you could be deported. If there's fraud in the immigration process, let's say you married a U.S. citizen, but the government believes it was a fraudulent marriage, your green card could be taken away. If you violate other immigration laws, like you help someone enter the U.S. unlawfully, which is smuggling them, your green card could be taken away. If you are a national security or terrorism-related threat, your green card could be taken away. We are seeing this be extended into the student context right now. So some of those high-profile student visa cases or professor cases of people who are here and they have their green card, if they attended protests or have political opinions that could be viewed as a national security risk or a terrorism-related risk, that's the basis for taking away those green cards right now. And then also a failure to remove conditions. So sometimes people don't know if they only have a 3-year green card, they have to petition the government to remove conditions on their green card to give them the 10-year green card. You have to do that before your green card expires. And we do get calls where people don't realize that they have to affirmatively ask the government to issue them the 10-year green card instead and end up losing their green card because of that.
Do we know, sorry to interrupt,
Yeah.
the criminal activity?
Yes.
That just seems like a very broad definition. Has that been defined out, like this is the specific criminal activity that would revoke?
So there is, and I could do a whole hour on what crimes qualify for your green card to be taken away. It's based on the state, and it's based on the language in the statute of the criminal code. So it's a case-by-case analysis on what crime are you charged with, and does the language of that statute have a specific intent requirement? Or is it just negligence? What do you have to do to be charged with that section? Or what have you pled guilty to? Or what have you been convicted of doing? And you have to look at the facts of the case, you have to look at the statute and compare to determine if we think the government is going to remove the green card based on that charge. We do work with criminal defense attorneys, and we have been working with the DAs so people who work in the criminal justice system understand that there are certain crimes that are going to make people deportable. And what has happened, not all the time, but there have been attorneys who haven't advised their clients, if you plead guilty to this specific crime, you are at risk of losing your green card and being placed in deportation proceedings. A lot of times, you take a deal, right? Like, plead guilty to this and all the other charges will drop. Plead guilty to this and you won't have any jail time. Without considering, if you plead guilty to this, what are the immigration consequences of pleading guilty to that? And we have seen some of those cases where someone comes into our office and says, well, no one told me if I pled guilty I was going to be deported. I was pleading guilty because I didn't want to spend time in jail. And so that was a gap that we found that we are trying to work more within the criminal justice system to advise what that means for people and that they should be aware that their green card can be taken away in some of those instances.
Thank you.
Yep. Oops. Okay, so let's say you make it through all of that. You come as a refugee or an asylum seeker, you get your green card, or you marry a U.S. citizen, you get your green card, and now you're finally ready to become a citizen. You are a citizen if you're born in the U.S., at least temporarily. That is being challenged in federal court right now as well. You could get citizenship based on your parents, if your parents are a U.S. citizen and you meet certain requirements, or you could be naturalized. Documents would be your birth certificate or your passport. You could have a consular birth abroad. This has happened where someone was on vacation and ended up giving birth in another country. If you register that birth with the embassy in that country, that child will be a U.S. citizen even though they weren't born here if the parents were U.S. citizens at the time of the birth. And you typically can't be stripped of your U.S. citizenship except in fraudulent cases. So once you become a citizen, that is the best protection you could have as far as immigration status. We have had a lot of people come into our office. They've had their green card for 20 years and never became a citizen. And there's different reasons why people choose to do that and choose not to. But maybe they've spent too much time outside the U.S. because they're retired and they never became a citizen and they want to go live in Germany and they're there 8 months out of the year. Because this has happened. They come back in, green card gets taken away. Well, if they were a citizen, you could spend as much time as you want outside of the U.S. Or not that people should be committing crimes, but if you're a citizen, being charged with a specific crime is not going to have your citizenship taken away. So there are benefits in addition to being able to vote, being able to serve on a jury, being able to partake in our civil government, as to why someone might want to apply for citizenship.
Hey,
Yes.
Can you run back to that one? I just
Yeah,
have a question.
sure.
So like, if there's, my brother-in-law, he's gonna have a baby here, like
Uh-huh.
any day now in
Yep.
Japan. His wife's a Japanese woman.
Mm-hmm.
So, so with that like consular report of birth abroad,
Yep.
like that has to be like, what's that process look like?
So there's a form
Yeah.
from the embassy, and you fill out the form and you take it to the embassy and they stamp it and you'll get a certificate that says consular birth abroad. The child is a U.S. citizen as long as a parent was a U.S. citizen. So if your family member, just one parent has to be a U.S. citizen.
Yeah. So like if they forget to do that form, do they have to call you in a couple years to sort all that out?
Well, there is a way to do it from the U.S. end to get that certificate, to get the child citizenship as well. But it is easier to just do the consular birth abroad.
Okay.
Yes. Okay, so that whole first half of all those definitions are what we call the affirmative process. The affirmative process are all the legal statuses, all the ways that someone would have legal status here or would be trying to get legal status here. That is completely different from deportation and removal. I wanted to make sure we covered both because I know there's a lot of questions about deportation and removal proceedings, especially right now. So there are three main ways to be placed in deportation proceedings. One is you enter the U.S. illegally. You go across a border, you go through the desert, you pay a coyote. However you get in, you don't go to a port of entry, you're not inspected, you don't have a visa, there's no record of you being here. The second is you entered legally, but you overstayed your visa. More people statistically in the United States enter legally and overstay their visa. So while there's a lot of talk about what's happening at the U.S.-Mexico border and people entering the U.S. unlawfully, more people fly on a plane, go through Customs and Border Patrol, are not trying to hide from immigration, are inspected, have a stamp in their passport, and then overstay their visa. And then the third is what we were talking about earlier. They have a lawful status, like a green card, or they have parole or TPS or whatever their status is, and it's being taken away because of a criminal conviction. Some of the changes we are seeing related to deportation is something called expedited removal. Previously, someone could be placed in expedited removal if they were found within a 100-mile radius of the border within the first 2 weeks of entering the U.S. So that was pretty limited. If you were caught by immigration after that 2-week period or further than 100 miles from the border, you would have to be served with an NTA, that's a notice to appear, which is the charging document that has your immigration violation charge, and you would get to see an immigration judge and go in front of the judge and present your case. Under expedited removal, there is no court date with the immigration judge. You are immediately served with a deportation order, very likely with a 5-year bar, meaning you cannot re-enter the U.S. legally for a 5-year period. Expedited removal has been extended to anyone not within a 100-mile radius of the border, anywhere in the United States within the last 2 years. If you've entered within the last 2 years unlawfully and you are caught anywhere in the United States, you are being placed in expedited removal, which means you do not get a court date with the immigration judge. You receive a deportation order and you are placed in, you are very likely on one of those planes going back to whatever country you're from. Unless you request what's called a credible fear interview, and you tell the officer, I want to be interviewed by an asylum officer, like we talked about earlier. I want someone to evaluate whether I have a credible fear of going back to my country so that I'm not deported. If you request a credible fear interview, you will get a determination from the asylum officer. If the asylum officer says, no, no credible fear, you can then be deported. If the asylum officer says no credible fear, you could also request reconsideration from the immigration judge. So you basically get a second chance. Asylum officer says no credible fear, you say, okay, I want the immigration judge to review this. The immigration judge can agree with the asylum officer or say, no, you don't have a credible fear, you're going to be deported. Now, you're doing that very likely without an attorney. Because again, one is not appointed for you. So those key words, credible fear interview, expedited removal, reconsideration by the judge, if you don't articulate that to your deportation officer, you very likely don't know you need to ask for those things, and then you are going to just be deported.
Is this something that, I mean, it seems like those are some very key phrases that people then need to have. Is this something where the city might benefit to pass out those as like cards so that people that are, I mean, you have to also make those requests in English, I presume?
Yeah.
Yes, you have to be able to communicate with the officer that's assigned to your case. They are supposed to provide interpreters for the hearings, but if you don't ask for the hearing, then there's no interpreter.
So is that something that, I mean, it seems like that's something that would be very beneficial for us to try to be providing.
Sure. We can do that.
And then another question, like with, I remember the stories around like Laken Riley. Like, has any of that changed, you know, compared now with like cases like that I've been reading about?
Yeah, so the Laken Riley is what I had kind of mentioned earlier, where a charge in itself could place you in mandatory detention or deportation proceedings. So different from the criminal justice system where you have to have a final adjudication, there are certain crimes that Laken Riley applies to, theft, burglary, larceny, something else. There's a list, and if you are charged with any of those things, doesn't matter if anything was withdrawn, you will be detained and very likely placed in deportation proceedings. So that has changed what's going on. We've also seen the invocation of the Alien Enemies Act of 1798 to deport individuals that are deemed to be a threat to national security, and so that has been challenged in the courts, and The most recent order from a judge said, this administration is allowed to use the Alien Enemies Act, but you have to provide due process. So you have to make sure that person still has a court date with the judge to plead their case. And what we're also seeing is effectuation of deportation orders to third countries. So let's say you win a case and the judge says, you have a fear of going back to El Salvador. You're not allowed to go back to El Salvador. You didn't win asylum, you won something called withholding of removal. What that means is we won't send you back to El Salvador because we believe there might be fear there, but that doesn't prohibit us from sending you back or sending you to Panama or Costa Rica or any other country that is accepting deportees. So some people are being deported to countries that are not their country of origin under the third country removals. ICE conducts operations in a couple different ways. Some are targeted enforcement actions. That means ICE has your name, they know your house number, it's very specific, they know exactly who they're looking for, they're going to your house, they're going to your place of employment, and they have a warrant for your arrest, and they are detaining you for immigration purposes. We also are seeing a lot of what's called collateral stops. So ICE is looking for a very specific person who happens to be with 10 other people who are undocumented. Doesn't matter that ICE was only looking for that one person, they're going to pick everybody up and process everybody. So you might be collateral to someone else's warrant. We're also, yes? The warrant? Oh, illegal, yes, undocumented, yep. Yes, so what we are seeing is if you are able to present a form of documentation that would allow you to legally be in the United States, typically you are released and you're not going to be processed. But we have seen people who have been here 20 years off immigration's radar. Immigration didn't know they were here. They don't have any criminal charges that would put them on the radar, but they were with someone who did have a criminal record, and maybe immigration was going after the person that had a criminal record. They're still going to pick up the person who doesn't have a criminal record because they're unlawful as well. We have seen ICE operate in public places where they do not need a warrant. So I have seen ICE outside of houses just parked on the street. They don't have a warrant to go in, they're waiting for you to come out. Once you are on the sidewalk, once you are going to your vehicle, once you're leaving work, once you're leaving the store, if you are in a public place, you are free game at that point. They do not need a warrant. Also, key note, there's a difference between a judicial warrant and an ICE warrant. A judicial warrant is signed by a judge. An ICE warrant means an immigration officer signs the warrant. It is not a judge that is signing an ICE warrant. The same immigration officer that signs your warrant might be the arresting officer. So there is not a neutral third party that is reviewing the warrant to determine if it's a valid warrant or not. That's something in the administrative law that has just been allowed to happen, and courts have said that that's okay. And the last is being arrested by the police for a criminal charge and then being transferred into ICE custody, or being stopped and being part of an investigation for some other reason and then being transferred into ICE custody. We're seeing a variety of people get detained. Some people already have court dates. They already have their trial date with the judge. They already have pending asylum applications. In the past, those people were not being detained and deported. There was kind of an unspoken, well, if they have a court date and they already applied and they have a pending case, we're going to go after people who don't have pending cases and who don't have court dates. That does not seem to be the case right now. Some people are attending their ICE check-ins. When you are released from ICE custody, it's kind of like probation. You have to check in with your deportation officer. They're getting notices for ICE check-ins, they're attending their ICE check-ins, they're following the ICE check-in procedure, and they are then being detained at their ICE check-in. So this is encouraging people to not go to their ICE check-ins. Well, when you don't go to your ICE check-ins, you're violating your parole status, and then you can be detained and deported for for not going to your check-in. It's kind of a lose-lose situation at that point. Do we encourage people to go to their check-ins with the risk of being detained, or not go knowing that you will be detained?
Are you able to tell me how DACA is being impacted by this? Because they are continuously in an application process and continuously going to check-ins and
Yes. So DACA is deferred action, childhood arrival. So those were for kids who were brought to the United States by their parents as minors, with the rationale of a minor doesn't have the intent to unlawfully enter the U.S. That's the parent's decision. So we shouldn't punish minors if the parent brought them here. DACA is what's called deferred action. So you still might be here unlawfully. You still might be in court, have a court date. You might even have a deportation order, but the government is deferring taking any action on actually removing you from the United States. We have heard mixed results across the nation as to what offices are detaining those who have DACA and which ones are not. The general consensus amongst immigration attorneys is people with DACA should not be impacted because they shouldn't be placed in removal proceedings because the action on their case is supposed to be deferred. But we have heard of cases where someone with DACA has been questioned significantly and even detained and questioned for a period of time before being released. So I don't think there's a one-size-fits-all answer to that. The other thing about DACA is there was just a decision a couple weeks ago in March. Right now for DACA, if you have DACA, you can renew DACA. If you don't have DACA, you can't submit a first-time application. So that has been in the courts for a very long time now, being challenged back and forth and being appealed and then being remanded back down. And so the Court of Appeals just remanded back to the district judge, sent it back down for consideration. So we should be hearing soon about what the future of DACA is.
Can you also tell me what can someone do that went through the 6 steps for a National Visa Center and was accepted but never received an application, since things are so tense right now?
So what do you mean? Okay, so National Visa Center means your consular processing. The first step is you submit an I-130 to USCIS. USCIS processes the application. If it gets approved, it gets sent to the embassy. Once it's at the embassy, there's another application you submit to the embassy, you go to an interview, you have to submit financial documents, and then potentially get approved and get the visa. So I'm not sure exactly what petition this is or where it would be stuck, but I would say the NVC, the embassy, they will not tell you to keep working on your case. So if everything's not uploaded to the Department of State system at the embassy, nothing's going to happen with the case. So the first thing I would make sure is everything actually is submitted and that something's not missing, because more likely than not, something is missing, and that's why nothing's happening with the case.
Okay, thank you.
And so other people who are being detained are people who previously were not enforcement priorities and now are. So the prior administration had 3 categories of people who were enforcement priorities. Those with a criminal record were at the top, those who entered unlawfully within the last 2 years, and there was kind of a tiered system of who immigration was going after, who ICE was going after. That does not seem to be the case right now as far as enforcement. It kind of seems like anyone who can be found is turning into an enforcement priority. You can request bond. If you are picked up by immigration and you are detained, you can request bond. Not everyone is eligible for bond, so you do need to figure out if you are eligible for bond. The best way to be eligible for bond is if you don't have a criminal conviction, you're not a risk to public safety, there's no security or terrorism concerns, you have ties to the community, you have a family member who can petition for you. Maybe you're a vulnerable population, so you're pregnant, you're a minor, you have a disability, health issues, and if you don't get out on bond, then you do have to remain in detention until your immigration court date with the judge, which could be months. And so the goal is to get people out on bond. What we have been seeing, people who are arrested and placed in criminal proceedings are paying their bond, and the families are expecting them to be released because they paid their criminal bond, and then they're being transferred into immigration custody. And when you're in immigration custody, you have to be eligible for bond again and pay another bond. So the criminal justice system and the immigration system are completely separate when it comes to bond. You might be eligible for bond from the criminal system and not be eligible for bond from immigration and remain in immigration detention until your court date, even though you were released from the criminal system. The role of ICE and police, so ICE is a federal agency. They're in charge of enforcing the immigration laws. ICE is broken up into two different categories. One is ERO, that's enforcement and removal operations. So those officers are in charge in deportation and detention, the bonds, and targeting people for removal action. And then the second group is Homeland Security Investigations, and they are in charge of investigating criminal cases and workplace enforcement. So HSI would be the one who is going to look at I-9s, go to employers and make sure that everyone has I-9s and all their books are in compliance with the workplace enforcement. Typically, local police are not responsible for enforcing federal immigration laws unless there is some type of an agreement for them to be cooperating. What we've seen locally in Erie, this was on Tuesday when I visited the jail, so I haven't been there since Tuesday. I'm not sure if this many people are still there, but there were 19 immigrants being held in Erie County Prison. Many who do not have criminal charges, it's solely for an immigration violation. You could be held in Erie County Prison because you committed a crime and then were transferred into ICE custody, but you could be held in in Erie County Prison because of this immigration violation. You're here unlawfully or you overstayed your visa. There's no criminal activity and you are still being held in Erie County Jail. Some people were taken into ICE custody directly by ICE. It was a targeted enforcement action. ICE showed up at the house, picked them up, brought them to Erie County Prison. Some were taken into custody after some contact with the police department. Maybe they were charged criminally or they had a prior criminal record and now they're being placed in ICE custody. But as I mentioned, many were detained due to a non-immigration matter. From Erie County Prison, just because we get a lot of questions about that, Erie County Prison is not an immigration detention facility. So you do not have access to the immigration court system while you are at Erie County Prison. It's a temporary holding place. From Erie County Prison, you'll be transferred to the Moshannon Detention Facility. That's by State College. And there is where you'll have your hearing with the immigration judge. And that's where you can also request bond. The issue that we've been seeing locally is Moshannon is full. So previously, people would be in Erie County Prison 2 or 3 days. It was very temporary, and then you would be transferred to Moshannon. The people I was visiting on Tuesday, which was the 8th, they were there since March 31st. Because there's nowhere to transfer them. And while they're there, there's no access to the immigration judge. You can't request bond because the court system doesn't have jurisdiction over Erie County Jail. So that is really affecting a lot of people who are there for a longer period of time. And then the last thing I'm going to cover before we open it up to any more questions is this new registration requirement. And this administration has said that on April 11th, which is tomorrow, anyone who's in the United States without proper documentation has to register with the U.S. government. If you don't register with the U.S. government, you could face civil penalties of up to $5,000. You could face 6 months in prison or both. And this is an ethical problem, and this is being challenged in court right now, because it's hard to advise someone again to say, if you don't follow the registration requirements, then you face all of these penalties, jail time or fines. If you do follow the registration requirement, that information is very likely going to be used against you, and you're going to be placed in deportation proceedings. So we're waiting for a decision from the courts right now. That lawsuit was filed last week to see how the courts are going to advise what to do. But in the meantime, I do believe it's going to become effective tomorrow, and people should consider whether or not they're going to comply with the enforcement.
And I'm also stuck on, I mean, there's a lot of things. My mind is like, it's everywhere. Age 14.
Yes. Yes,
I just
14
wanted to,
or older.
say
And so the
14.
other interesting thing that we have had is some families entered when the child was under 14, or maybe they have children who are under 14 now. They're not required to comply. But then if the child does turn 14, having to comply with the registration, and some family members not have to register, but others might have to register, that has been causing confusion and complication as well.
So a 14-year-old can be charged with criminal charges without registering.
That is what it says on the face of the regulation. That is one of the questions a lot of attorneys have is, are you going to enforce this against a 14-year-old? On the face of it, it appears that's how they've written it.
Thank you.
So I would be happy to take any questions. I don't know if I can, is this camera the one that's recording me right there? Or can I turn this way to see people?
So typically, we have the questions, I mean, every now and again we'll have some questions, but it's typically just the ones from
Okay.
council that come up. Do any counselors have any questions?
Can you, well, I have a bunch. I had people send me, I already pre-sent them to you so you would have an
Yes,
idea.
I do have the rest of yours.
So I just wanted to know, well, I guess I'll just tackle this one. How does the county prison agreement impact the involvement from local prison? I mean, local police with the ICE, with
Yes.
us being like a holding station, I guess you could say?
Yes, so there is a contract between Erie County and the federal government for Erie County Prison to hold people in ICE custody. And so it's a de facto holding facility. It's as if they were in an immigration detention facility, even though it's Erie County Prison. So that agreement allows the county to get reimbursements from the federal government for holding people there. I don't know any of the numbers. I'm not sure what the reimbursement scale is. I do know that the county executive has spoken about the contract, and from my understanding, local police are not involved in that. The person is in immigration custody. ICE brings the person to the prison. They are placed in a separate pod, and that pod is for ICE holds, for people in ICE custody. So they are separated from the rest of the population, and anyone there would be up to the discretion of when immigration is going to come to transfer them to the detention facility.
Are you able to give us any insight on why they were detained for traffic violations? Because that seems like very minor and non-violent and not, criminal.
Yes.
I speed not as much as I need to, but sometimes I have to catch myself that I'm in a 25 and not a 35.
Yes. I don't have solid answers to that, other than I know the city is aware and we're working through what that could look like, why it might have happened, what the policy and procedure could be moving forward. But I don't know the actual answer to that question.
And I would assume that if they're picked up on traffic violation, then something's happening with their cars. So what's happening? Are they getting towed away? Are federal agents permitted to take the vehicle? Do we know what's happening? Are families notified?
Yeah, I think you're talking about the incident that happened yesterday or the day before. I did see that video. I have never seen a federal agent get into a vehicle and drive it away the way that I saw it in that video that was recorded and shared among social media. I am not sure where that vehicle went. I am not sure if it's immigration custody. It definitely was an ICE officer that drove that vehicle away, and I do not know where it went. I don't know if it's being processed, but I have not seen that happen before in that way. I thought that officer I thought it was a person in the vehicle with the driver. I didn't realize it was a separate person until I rewatched it a couple times.
Anyone else have any questions?
Do you know how many ICE officers there are in the Erie County area versus other cities throughout the United States?
I don't. I do know that there's a CBP location in Fairview, and so a lot of people are being taken to that Fairview CBP location and processed and then taken to the
What do
jail.
those initials stand for? I'm sorry.
Customs and Border Patrol.
Thank you.
Yes. So there is a Fairview location. Erie is also a border city. We're within a 100-mile radius of the border, so that gives Customs and Border Patrol and ICE officers a lot more discretion in their searches, their seizures, and what they're doing because of us being a border city. A lot of the officers in Erie who are ICE officers are probably coming from the Pittsburgh office. There's a subdivision of the ERO, the removal operations in Pittsburgh. So what we're seeing is a variety of people. I have seen people with HSI, so Homeland Security Investigation logos. I've seen people with ICE, Immigration and Customs Enforcement, and I've seen people with CBP, Customs and Border Patrol. All three of those agencies have the ability to effectuate an ICE warrant and detain. So I don't know how many of each of those officers, but you could see any of those people doing these enforcement operations.
So years ago, I had a woman from Russia live with me, and she obtained her green card. She had to go to Buffalo.
Yeah.
So I can't remember how many times she had to go to Buffalo, but let's say she didn't want to be in Erie. Could she move to a different city, but would she still have to report to Buffalo eventually?
No, so there's two different systems at play. Buffalo is USCIS, that's U.S. Citizenship and Immigration Services. That's the office that adjudicates green card applications and citizenship applications for people who live in Erie. So they also process fingerprints. So someone might be going to Buffalo for fingerprints or for their green card applications or citizenship. If your case is pending with USCIS, with that government agency, you are allowed to move. You have to update your address with USCIS within 10 days of moving, and then your case will be transferred into whatever jurisdiction you've moved to. So if you move to Pittsburgh, there's a Pittsburgh USCIS office. Your case would then go to the Pittsburgh USCIS office instead of the Buffalo USCIS office. If you're in removal proceedings, so you're in court and you have to see an immigration judge, which again is a completely different process, that's why this gets so confusing. The immigration court, there's only one in Pennsylvania, it's in Philadelphia. There's a sub-office in Pittsburgh. So if you have an ICE check-in and you live in Erie, you're very likely going to Pittsburgh for your ICE check-in, or you're going to Philadelphia for your court hearing. If you move, you also need to let your deportation officer know, you let ICE know, and you let the court know that you've moved, and then you can petition for your case to be transferred to whatever court you've moved to. So if you've moved to Buffalo, there's a Buffalo Immigration Court, and then you could request your case be moved to Buffalo or your ICE check-ins in Buffalo or wherever you're moving. But there is an obligation to let the federal government know where you've moved in both of those systems.
Any other questions?
Hey, I think there was a couple of us that were very moved by your public comments that you offered a couple meetings ago.
Yeah.
And, I realize you're not getting this isn't exactly hourly billable. So I just really want to thank you,
You're welcome.
as a member of our city and as a neighbor to our community, that you would come here and help us to not just be informed, but also that we would be able to inform our constituents and get this out there to make sure that our neighbors are protected. So I mean, this is volunteer work for you, and I really appreciate knowing how valuable your time is as like the expert in Erie on this.
You're welcome.
And the fact that you're the only immigration lawyer in our area, it's great to be able to give people your information and your contact, because I feel like we're going to need this in the coming months and years until things get back to normal.
Yeah, so our firm does immigration, and there are 2 other attorneys that I work with as well. So we do divide and conquer.
I just want to reiterate my gratitude for you taking the time this evening because it's educating us so we can educate others, but there are many who I know who are going to be streaming, who are watching this, who are going to feel more empowered and who are going to understand a lot more. So by giving us this, you've helped us educate a lot. And so I'm genuinely very, very grateful for everything you've done. If there are no other questions, we are a little over, so I'll go ahead and we can close out this study session. I have lots of questions, but
It's
for another
very
time.
complicated, yes.
Spend much more time
definitely
in your
send
billable
more.
hours.
Yes.
I'll send you some emails with additional information on the couple questions I didn't ask, just because
Sure.
when I received the questions, I was a little, it made me question, I don't even know what that means, so I hope she knows what that means.
Yes.
So I'll make sure I get a little
And
bit
this
of
is,
clarification.
it's very fluid. So this is changing all the time.
Every day, probably.
Yes, every day, every week. So if it would be valuable in any way to have another one or to have a direct line to council to share the updates and how things are changing, I'd be happy to do that. I understand how confusing this is. And this is just the the tip of the iceberg. I was trying to fit in as many different categories and as much information as possible, and each of these different categories could have an hour in itself. We teach a class, and it's a whole semester, 15 weeks of this information, so it's very, very complicated.
Thank you for
Thank
your
you.
time.
And thank everybody for attending and watching. Thank you.
Thank you.
Thank you.